Day FDP on IPR, issues and challenges. Dear participants, you must be eagerly waiting to know about our guest speaker of the day. Our guest speaker for today's session is Mr. Vishal Shukla, Assistant Controller of Patent and Design, Patent Office, Delhi. Mr. Shukla is an IP consultant with more than 11-year experience at various key positions. During last 3 years at Patent Office, Delhi, Mr. Shukla is taking up various key projects of Government of India and is an instrumental in formulation of policies. Mr. Shukla completed his BTech in Computer Science and Engineering in 2010. He started his career as a software engineer in Accenture, India, Chennai. After serving for almost 2 years as a software engineer, he joined Patent Office, Mumbai, where he has the role of an examiner of patent and design for 6 years. Above all, I feel honored in sharing with you that Mr. Vishal Shukla is an alumnus of IMS Group of Institutions. Now, I would like to request our honorable guest speaker, Vishal Shukla ji, to take this FDP to the next level. Over to you, sir.
Thank you, Rakesh ji. So, today's topic is related to the first topic is related to the patentability. Am I audible?
Yes, sir.
Yeah, okay. So today's topic, we start with the patentability and then we move to the non-patentability invention. And after that, I told we will go with the topic type of application and filing procedure. So before starting with the patentability criteria, I would like to introduce what is the intellectual property. Because as you know that the physical property is very much known to the general public, but the general public don't know about what is the intellectual property. So intellectual property is very important concept and very valuable things, but many of people don't know about what is the intellectual property. IP means a creative idea and expressions of the human mind that have commercial value. Intellectual property is an asset. It can be bought, sold, mortgaged, licensed, exchanged, etc. like any other form of property. So, key issue is related to the ownership of knowledge. Once a person have a unique idea or expression, he need to protect his idea with the help of that IP rights. What is IP rights? There are several IP rights. For example, patents, copyright, GI, geographical indication, trademark, trade secret. There are many copyrights, many IP rights. So I have an innovation. So how do I protect it in the market? We have to select the right choice of that IP, whether it may be patented or whether it is copyrighted or whether it is design protected. We have to identify in which format of IP we can protect our idea. So today we discuss about only the patent. What is patent? Patent is an exclusive right given to an inventor for disclosure of his invention by the government, and it's a territorial right. What is mean by the territorial right? It is country specific. If a person given a patent in the India, that is applicable only India only. If he wants to take the protection of his innovation, his invention, he has in a different country, he has to apply different application. So it's a territorial right, and it works on the concept of quid pro quo. What is the meaning of quid pro quo? Quid pro means give and take. Inventor has to disclose his invention to the government, and government give a 20 years exclusive right to the patent to the inventor to marketize his invention exclusively. No one can exploit his invention without his permission. So patent is an exclusive right given to an inventor for disclosure of his invention by the government. The patent administered by the two main act, Patent Amendments Act 2005 and Patent Amendment Rule 2006. An invention what is an invention? Move to the next slide. First of all, many person is confused between the discovery and invention. Discovery refers to the act of finding or exploring something which already exists in the society or in the in real world, but not perceived before. That is known as a discovery. Invention is creation or designing an items or process which has never been existed before with own ideas or developments. So this is a basic difference between discovery and invention. And discovery cannot be patentable, but an invention can be patentable. Basis for there is some comparison between discovery and invention, because discovery refers to the act of finding. This is the definition itself. And as I already said, that discovery cannot be patentable, but invention is patentable. Move to the next topic, criteria of patentability. So as per the section 2(1)(j), invention means a new product or process involving an inventive step and capable of industrial application. So there are major three criteria of patentability. First is novelty, that newness. Second is inventiveness, and third is industrial applicability. I have given the link of that section in my slide. So what is patentable? All process and products. Only the process and product can be patentable, no other things. So all process and products that are new, involving inventive step and capable of industrial applicability, and not barred by section 3 and 4 of the Patent Act. We will discuss the section 3 or 4 of Patent Act after that. Before that, we discuss what is the newness. Product means apparatus, devices, machines, chemical products, drug, food and their composition, chemical composition, biological products. And process may be making of that product, process may be using of that product. So either a process or a product can be patentable, no other thing. Novelty is subject matter described in independent claim. There, once an inventor is filed the application for the patent, he has to file in the form of claim. Claim is the boundary which is which protection is given by the government to the inventor, and claim is what is the product and what is the feature, technical and structural feature of that product or process. So claim defining the boundary of protection. So subject matter described in an independent claim is not novel if all features are known from a single piece of any prior art. Prior art is, what is prior art? Prior art, any information that is available to the general public until the application date or priority date. Priority date is the date in which the application is first filed in any of the anywhere, any patent office, maybe outside of India, maybe within India. So priority date is decided on the basis of first filing application, and the filing date may be same as the priority date if the filing country is India only. So what is the prior art? Prior art is disclosure made available to a public by a written description or by use or oral description or in any other way, example accessible through file inspection. So which is any information which is present in the form of written description or by use or by oral description or in any another way accessible through file inspection can be considered as a prior art. There is one more notation that it is not enough that the information exists in somewhere. It need to be in public knowledge, because without public knowledge it cannot consider as a prior art. It should be in public knowledge. Subject matter described in an independent case is not novel if what if not? If all the features of a single piece of the invention is not known within a single prior art, then what if? If a feature is not explicitly mentioned, but the feature is implicitly implicit for the someone skilled in the art, and when he reads the prior art, subject matter is also considered as a not novel. That there may be some explicitly disclosure in the prior art, but there may be some implicit indication that the invention is possible, then it considered as a not novel. There may be some nomenclature difference in the prior art. There may be some different word is used for the same feature. Then also in that case, the subject matter is considered also not novel. For example, if an invention feature A has a feature A, B, C, D, there are 4 features of invention in the your application, and it's a document which contains the only A, B, C feature, it is considered as a novel. If a document consider feature A, B, C, and F, there are another feature, then it is also considered as a novel, because D feature is missing in the document 1, 2, and document 3. But the document 4 and 5, which has consists the A, B, C, D feature and any additional feature, F feature, then it considered as a novel, not novel invention. Move to the next concept of the patentability, that is most important concept, that inventiveness. What is the meaning of inventiveness? Inventive step means a feature of an invention that involves technical advancement as compared to the existing knowledge, or having economic significance, or both. And further, most important, that makes the invention not obvious to a person is in the art. So for assessing the novelty inventive step, the knowledge of a fictitious average expert, someone skilled in the art, has to be taken into account. So what is the technical advancement and what is the economic significance? One has to know what is the technical. There should be some advancement of the invention over the cited prior arts, that there some technical advancement, there some benefit, some efficiency has improved, some functionality has been improved, then it is known as a technical advance. And economic significance is related to the more that it may be cost effective, it may be the time effective, then it is known as economic significance. So an invention has both the technical advancement and economic significance over the existing knowledge or over the cited prior arts, and that makes an invention not obvious to a person in the art. The knowledge or skill of the average experts depend on the technical field or the complexity of the subject matter of the invention. That it may be an engineer if an invention related to a communication technology, but it could be an artisan. Example, if the invention is about a tool, so that person is the art is a imaginary person which has complete knowledge of that area. That area, if the invention related to communication field, the person in the art may be communication engineer. And if a invention related to the tool, there may be the person in the art may be some mechanic and some other technician. So inventive step is only judged when your filed application or filed invention is completed the criteria of novelty. If a invention is not novel, then there is no meaning of judging the inventive step. So first, the newness of the invention is compared. Once the newness is established, novelty is established, then we move to the inventive step. If an invention is new, so we have to judge whether this invention is inventive or not. For judging the inventiveness, we have to judge what is the closest prior art, and in light of the problem to be solved, would an expert combine knowledge from different prior arts and complement such knowledge with his knowledge? Any combination of prior art is possible. It need to be convincing argument why an expert would combine more than one prior art. So for inventive step, a person can combine more than one prior art and reach out to your invention. For example, earlier said that a invention has a feature A, B, C, D, and document 1 has feature A, B, C, and document 2 has feature A, B, C, F. So in comparison to document 1 and 2, both the invention is novel. But if document 6 has the feature of D, then it is not inventive over the citation of the document 1 or 2, and in combination with the document 6. Next concept is the industrial applicability. Only the novelty and inventive step is not sufficient for the judging the criteria of patentability. Inventions also has the capability of industrial application. In relation to an invention means that the invention is capable of being made or used in an industry. So that industrial applicability criteria is for judging whether your invention is can be applicable or used in an industry or not. If it is not capable of using in an industry or any commercial exploitation, then it cannot be given as a patented. For example, there is one example in the slide that
सर म्यूट हो गया सर, आपका स्पीकर माइक म्यूट हो गया सर, अनम्यूट कर लीजिए.
Yeah. So, for example, a method for inducing cats to exercise consists of directing a beam of light produced by a hand and laser apparatus onto the floor or wall or any other opaque surface in the vicinity of the cat, then moving the laser so as to cause the bright pattern of light to move in an irregular way, fascinating the cat and to any other animal with a chase instinct. So, this invention is related to the exercise of cat. We can make the cat with the exercise with the help of a laser light. We are moving the laser light and the cat is chasing that light. So whether it is considered as a patentable or not. As I earlier told that the third concept of patentability is industrial applicability. So this invention may be novel or inventive. It may be judged during the searching of the prior, but it cannot be industrial applicable because it cannot be used in an industry, or it cannot be it cannot be used in industry. So it is not industrial applicable. Therefore, the patent cannot be given that invention. So we have some interesting invention. For example, you have seen that the Michael Jackson is making the moonwalk and that anti-gravity move. So there is one inventor who designed a shoe such that the wearing person is appear that he moved the anti-gravity move. That allowing a shoe wearer to lean forward beyond his center of gravity by virtue of wearing a specially designed pair of shoes with the help of engage a hitch member. Hitch member is some spring may be introduced in the front side of a shoe, and which increase the height of the heel, and it appears that the wearer person is leaned to forward. So this invention is may be patentable if it is found the novel or inventive, because it is industrial applicable. A shoe can be made in an industry. Such type of shoe can be made in an industry and can be used in an industry. Second, next invention is teenager. That simple of idea can make a patent, and it can be very useful in the society. In our daily life, we are using many such things which are patented, like pressure cooker and many other things is patented and with a small amount of modification. For example, a Robert Patch, who was just 6 years old, invented a toy truck, and that toy truck is nowadays using as a dump truck. That concept of his toy truck is used in nowadays used as dump truck. So a 6-year-old boy can get patent with his own new idea or with his inventive idea. Second invention, very interesting invention, that a 12-year age student made a toothbrush, and which has some syringe type of structure at the rear end, and a paste is inserted in that syringe type of structure, and once that syringe is injected, the paste come to the brush of that toothbrush. So a simple concept of injection and toothbrush is admixtured and invented a new type of toothbrush. This is given as a patent. For example, a plant self-watering plant apparatus is made by a 10-year age student. That he make an arrangement so that for a certain time the water is given to the that plant. So self-watering apparatus for a plant. So if a person identify what is the exact problem of our daily routine, he can invent get the solution to overcome that problem, and can invent many things. So that simple ideas make a patent. For example, 11-year age student Georgia Dinsley make a box for pulling up the pingles out of the box. He made a instruments in which the pingles are piled up, and with the help of that support structure, he can get up the pingles. Versa in India, Versa proposes a system where the driving license is swiped like a credit card machine, and the vehicle starts only a pre-authorized license is swiped. So that vehicle and that license can be interlinked, and once that particular license is swiped, then only the vehicle is started. So this also protects the car against theft. So this is a unique idea and given as a patent. For example, many of you seen that the tree climber device. A person of the South Asia made a device for climbing a palm tree or any coconut tree. Our nano car, the cheapest car in the world, which is invented by the Tata, it is given a 31 design and 37 technology patents. In a single car, there are 37 patents which is given to technology, the technology of nano car. some jugaad innovation is also there in our country. We have very good in the jugaad technology, that a person made a helmet with the structure of rear mirror. A lady make a solar illuminated lamp with the help of a plastic bottle and filled up the illumination liquid.
Vishal sir, sorry to interrupt you in between. Actually, I believe you are having some PPTs, but we could not able to see that. Can you share your PPT? Screen
I have
share.
shared that PPT.
You have to run the slideshow just.
Right.
Share your screen.
Share
Share your screen, and the slideshow will be functional.
Oh, sorry, you have to tell me before, because I am understand that you have that PPT.
No issues, no issues.
I have requested to you in chat also personally. So I thought you could not have seen that.
How could I share that screen?
At the lower side, you must be having share screen option, just upside arrow, green color in your system. Just at the bottom
Yeah.
where participants is written, chat and then share. Yes, sir. It's visible now.
Now it's visible.
Yes.
Oh. So a person who made a tractor with the help of his bike. M.Sc by Jagani's motorcycle-based tractor is both cost-effective and costing roughly $318 and fuel efficient. It can plow an acre of land in 30 minutes with just 2 liters of petrol. So such type of arrangement is very innovative and can be given as a patent, and he gets the 20 years exclusive right for his ideas. So we move to the next topic. The next topic is related to the non-patentability. What is the invention that is not patentable?
Please share your screen again, sir.
Yeah, one second. So the invention which is not patentable is disclosed in the section 3 and 4 of the Patent Act.
Sorry, sir, your screen is not shared. Yes, it's coming now. Yes, sir.
Yeah. So section 3 and 4 is covering the invention which is not patentable. Section 3 is related to the what are not inventions. Section 4 is invention relating to atomic energy and which is considered as a not patentable. These two type of invention is covered non-patentability criteria. If once the section 2 an application is clear the criteria of patentability, that the criteria inventive novelty, inventive step, and industrial quality is made, and the application passes these three criteria, then we judge whether it is falls under the section 3 or 4. If it is falls under section 3 and 4, so although it has the criteria of invention, but it cannot be given as a patent because it is excluded from the patentability. This subject matter is disclosed in the TRIPS agreement. TRIPS agreement is an agreement with the in between the countries of WTO, that World Trade Organization, and which followed by all the countries which is member of the TRIPS agreement. That Article 27 of TRIPS is told about what is the subject matter which is excluded from the patentability. For example, frivolous inventions, and in detail we told that section 3A. Section 3A is an invention which is frivolous or which claims anything obvious contrary to well-known established natural law is considered as a non-patentable. For example, a process of culturing microorganisms without using culture medium, because it is not possible without using a culture medium, a culturing microorganisms happen. So the thing which is cannot be possible in the natural law cannot be given as a patent. It is against the natural law. It may be against the well-established law. Maybe, for example, without giving any input, a person making the 100% efficiency.
Sir, we are not getting a voice.
It's audible, sir. It's audible. Just okay.
Yeah. So it cannot be possible. The things which cannot be considered as a possible and under the general physics law, general natural law cannot be given as a patent. For example, a process for producing a superman having 10 times memory and muscle power as compared to a normal human. So any person which is claiming such type of his invention cannot be given as a patent, because it is frivolous or it is against the contrary to well-established law, natural law. 3B is an invention, the primary or intended use or commercial exploitation of which could contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life or health or to the environment. So the invention which is against the public health or against the human health or animal health, and which exploitation produces any harm to the life, cannot be given as a patent. For example, the process for modifying the germ-line genetic identity of human beings cannot be given as a patent, because it modifies the genes of the human. Any device, apparatus, or machine or method for committing theft, it cannot be given as a patent, because it's against the law. Any machine or method of counterfeiting of currency notes, so it cannot be given as a patent. Any device for gambling. However, if the primary or intended purpose of commercial exploitation of claimed invention is not causing serious prejudice to a human, animal, or plant life or health or to the environment, such subject matter be considered as an invention and may be patentable. For example, pesticides. Pesticides can be given as a patent. If a person is making a new or inventive pesticide, he can be given as a patent. 3C, the mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature cannot be given as a patent. So discovery of any existing thing cannot be given as a patent. I already told in the initial slides. For example, a process for isolation of the gene responsible for which baldness from the DNA sequence cannot be given as a patent. Next, section 3D. Section 3D told that tells that the mere discovery of a new form of a known substance which does not result in an enhancement of the known efficacy of that substance, or the mere discovery of any new property of the or new use of known substance, or the mere use of known process, machine or apparatus, unless such known process result in a new product or implies at least one new reactant, cannot be given as a patent. For this purpose, this class, salts, esters, ethers, polymers, metabolites, pure form, particle size, isomers, mixture of isomers, complexes, combination, and other derivatives of known substance shall be considered to be the same substance unless they differ significantly in properties with regard to the efficacy. If any person make a get a patent in the known substance, and he modified that substance with any isomer of that substance or any salt of that substance, cannot be given as a patent without proving that this salt or isomer is improving the efficacy of that substance. So without improving the efficacy, the salt or isomer of that substance cannot be given as a new patent. There is one example of Novartis challenge. In that Novartis challenge, Novartis file a case against the government of India of one half is medicine related to the leukemia drug Gleevec. So court has rejected his appeal, and because that efficacy or effectiveness is not defined in our act, and however the honorable court defined that the term efficacy is a therapeutic efficacy or effect. Section 3 is told about tells about the invention which is related to a substance obtained by a mere admixture or resulting only in aggregation of the properties of the components thereof, or a process for producing such substance is not given as a patent. For example, a process for preparation of novel formulation of formula 1 which comprises mixing of paracetamol and ibuprofen in the ratio of 2:3 to 1:1, and pharmaceutically acceptable excellent in a manner as herein described. Said composition exhibits antipyretic and anti-inflammatory properties, cannot be given as a new patent because he is just modifying the ratio of 2:3 to 1:1. That combination is already known. That ibuprofen and paracetamol is already known in the our existing prior art, and he is just modifying that ratio of admixture 2:3 to 1:1, and which is not increasing the efficiency or any properties of that composition. Then it cannot be given as a new patent. And mixture with synergistic output are considered to be patentable. A mere aggregation of features is different from a combination invention. The features are linked by their function and show a combative effect beyond the sum of their individual effects. That synergistic effect should be brought out in the description and by way of comparison at the time of filing of the application itself. That comparison of the admixture and what is the that synergistic effect over that known composition. It need to be proved at the time of filing of your invention. Section 3F related to the invention, that is just related to the mere arrangement or rearrangement of or duplication of known devices, and each devices independently of one another, functioning independently of one another in known way. For example, helmet with fan, bucket with torch. A person came with the invention that a helmet has a fan, and both are working independently. Helmet is working for the safety purpose and fan is working for the cooling purpose. And an inventor is combining both the devices and just produce a new device, helmet with the fan. But it cannot be considered as a patentable because it is just arrangement of two different devices and which is working independently. And bucket with torch, a person made a bucket with the torch. And for example, in previous that the people are used to take the bucket and move to the farm, and so a person make a bucket with the torch. So without carrying the torch, he can take in bucket in a single hand, and torch is assembled with that bucket. So, but it cannot be given as a patent because it is just a combination of torch and bucket, and he's just combining these two different devices in a single device. So it cannot be considered as a patent. But if the function of torch or bucket is affecting each other, then it cannot be. It can be considered as a patentable. If both are working as independently, it cannot be considered as a patent. But it is working dependently, then it considered as a patent. For example, he makes such arrangement that if a bucket is lifted, the torch lit up. If bucket is put down, the torch get off. So if he makes such type of arrangement that the function of bucket affecting the function of torch, and then it can be given as a patent. So this is the major difference between the mere arrangement or any novel, any patentable arrangement. Section 3H is related to a method of agriculture or horticulture cannot be given as a patent. जो आप खेती करने का तरीका या बागवानी का तरीका cannot be given as a patent. Method of producing a new form of known plant, even if involved a modification of the condition under which natural phenomena would pursue their inevitable course, is not patentable. Method of producing mushroom, method of crossbreeding, it considered as a non-patentable. 3I is related to any process for the medical, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human beings, or any process for a similar treatment of animals to render them free of disease or to increase their economic value or that of their products. So that process for medical surgery or diagnosis cannot be given as a patent, because if a patent given in that field, that field is related to the life of a human or life of an animal. So our section 3I moved that type of invention purview of the patent. For example, laparoscopy, surgical method, keyhole method, vaccination, weight reduction, radio diagnosis involving the collecting samples from a subject, treatment method to increase the yield of cow milk, is not considered as a patentable. Section 3. One second. Yeah. Section 3J. Section 3J relates to the invention that is related to the plants and animals in whole or any part thereof, other than microorganisms, but including seeds, varieties, and species, and essentially biological process for production of or propagation of plants and animals. So that cannot be considered as a patentable, because section 3J barred that type of invention. Plants in whole or in part, animals in whole or in part cannot be get patent. Seeds cannot be get patented. Varieties of and species of plants and animals cannot be get patentable. So essentially, plants are excluded. Plants are excluded from this section because they are already protected under the Protection of Plants, Varieties and Farmers' Rights Act 2002. So there are some category of in the section 3 which are already protected in different act of IP. That's why that invention cannot be given as a patent. For example, next section is section 3K. Section 3K is related to the invention which are related to mathematical or business method or computer program per se or algorithm, cannot be given as a patent. So a mathematical methods are particular example of the principles that purely abstract or intellectual methods are not patentable. Mathematical methods like methods of calculation, formation of equations, finding square roots, cube roots, and all other similar acts of mental skills are therefore not patentable. However, mere presence of mathematical formula in a claim to clearly specify the scope of protection being sought in an invention may not necessarily rendered it to be a mathematical method claim. Also, such exclusion may not apply to invention that include mathematical formula and resulting in a system for encoding, reducing noise in a communication, electronic system, or encrypting, decrypting electronic communication. Business method cannot be get patentable under Section 3K. The term business method involves a whole gamut of activities in a commercial or industrial enterprise relating to a transaction of a good or services. The claims drafted not directly as a business method, but apparently with some unspecified means are held non-patentable. So there may be some confusion between that once we told that the patentability criteria is the industrial applicability, and now I am telling that Section 3K is barring the business method from the patent. But there is difference between the industrial applicability criteria and what is the business method. Method of doing business, some business is considered as business method, but the industrial applicability is related to the use of that invention in an industry. That invention can be used in an industry. That considered as an industrial applicability, but the business method is different from that. Business method is method of doing some business, method of doing some transactions or some exchange of goods and services is considered as a business method. Algorithm in all forms, including but not limited to set of rules or procedure or any sequence or of steps or any method expressed by way of finite list of defined instructions, whether for solving a problem or otherwise, whether employing a logical, arithmetical, or computational method, recursive or otherwise, are excluded from the patentability. So algorithm cannot be get patent because it is not. It is algorithm is an abstract idea. It is if an inventor is claiming an algorithm which cannot be directly implemented into the real world. He has to claim the his invention in such form that that is implemented in the real world. Algorithm is an abstract idea which cannot be given as a patent. Computer program per se is also cannot be given as a patent. Claims which are directed towards the computer program per se are excluded from patent, like claims directed at a computer program set of instructions, routines, subroutines, database, storage medium. These are not get patent, excluded from the patent. Section 3L. Section 3L is related to the literary, dramatic, and musical or artistic work or any other aesthetic creation whatsoever, including cinematic, graphic works or television production, which that cannot be given as a patent. Architecture, because these type of artistic work and musical and literature work is covered only with the help of Copyright Act. It can, that's why the patent cannot be given for that type of invention. Section 3M related to the mere scheme or rule or method of performing mental act or method of playing game. This cannot be given as a patent. For example, Montessori method of teaching. Someone is claiming the new way of the teaching, but he cannot be given as a patent because it's a mere scheme. It's a mental act. Asanas in yoga, meditation techniques, which these cannot be given as a patent. Section 3N related to the presentation of information. Any manners, means, or method of expressing information, whether visual, audible, or tangible by words, codes, signals, symbols, diagrams, or any other mode of presentation, example, encoded codes and signals, cannot be given as a patent. Section 3.0 related to the topography of IC, integrated circuit. It cannot be given as a patent because it is covered under the circuit, that Semiconductor Integrated Circuit Layout Design Act 2000. So that protection is given under that act. So that's why the patent is not cannot be given to the topography of ICs. Section 3P. Section 3P is related to the invention which in effect is traditional knowledge or which is an aggregation or duplication of known properties of traditional known component or components. For that purpose, a person cannot be get patent for that traditional knowledge. For example, we know that there is some issue between India and US related to the basmati chawal and related to the turmeric. That a company in the US is get patent for the turmeric use of turmeric in the medicine purpose. So that use of turmeric for the medicine purpose is known in the traditional knowledge of our country. In ancient times, we are using the turmeric for that medicinal purpose, therapeutic purpose. So once the US that person get the patent in the US, the exportation of the turmeric is banned in the US. For that purpose, the India raises his voice and that he filed a suit, filed a case in the US and produces the evidence that in our ancient books explain the use of that turmeric for the therapeutic purpose and medicinal purpose, and that's why it cannot be get patent because it is already known in our traditional knowledge. So that the invention which is related to the traditional knowledge cannot be given as a patent. Section 4. Section 4 relates to the invention which is related to the atomic energy and which cannot be given as a patent. No patent shall be granted in respect of an invention relating to atomic energy falling within subsection 1 of Section 20 of the Atomic Energy Act 1962. So that atomic energy substance is excluded from the patentability because these are very matter related to the Atomic Energy Act. Under this act prescribes, according to Section 21 of Atomic Energy Act, atomic energy means energy released from atomic nuclei as a result of any process including the fission and fusion process. Under this act, prescribed substance means any substance including any mineral which the central government may by notification prescribe being a substance which is in opinion is or may be used for production or use of the atomic energy or research. The updated list of that prescribed substance is attached in the link which is shared in the slide. There are some example of that excluded substance: uranium, thorium, radium, graphite. These substances cannot be given as a patent. Any invention related to the use of this type of substance cannot be given as a patent because it is excluded, considered as atomic energy substances. So that's all, that these type of invention cannot be given as a patent. And now we move to the next topic. You got the roughly idea about the patentability and invention which is not patentable. Now move to the how we can file the patent, how we get the right of our patent, because many persons have unique ideas, unique thoughts, and any person make a solution of a known problem in a unique manner, but he cannot aware of the process of patent and how he can get the protect his idea and get the patent. So for that purpose, I'm sharing the next slide. So filing procedure of patent application. With the help of this slide, I am explaining how you can file the a patent application in our office. So who can file the patent and when he has to file that patent? A patent can be filed by the true and first inventor, or assignee of that true and first inventor, or legal representative of that true and first inventor. So the application filed by either alone or jointly. It may be filed by the joint of two applicants, or may be filed alone. The inventor by any person claiming to be a true and first inventor is known as an inventor. Second, by an assignee of the inventor. By any person being the assignee of a person claiming to be true and first inventor, the natural person, the legal entity, proof of assignment has to be submitted along with the application. If any assignee of the inventor is filing an application, so the proof of that assignment should be submitted along with the application. And by the legal representative of any deceased person or assignee, a patent can be filed. So the right with inventor may be different, but the right is given to the applicant only. So if any person make an application for the patent, he has to show that maybe his name is included in the inventor, but if he wants to the right of that invention, the name of that inventor should be included in the applicant. If he wants the right, only applicant has to given the right of that patent. When an inventor has to file that patent, as soon as you file that patent, you get the priority of that date. Once you file that application, on which date you have filed that application, the date is given to that invention. That priority is considered from that the date of filing date. You can file either the provisional application or the complete specification. Provisional specification means that you have idea. You have idea what is the invention. You have layout of your invention, but you are not sure about the procedure of that invention. So you can file the provisional specification, and within 12 months you have to file that CS, that complete specification of regarding that provisional. Within 12 months you can file that CS. So you have the window of 12 months to complete your invention and disclose your invention in the office. There are categories of applicants: natural person, startup, small entity, legal entities. So jurisdiction is in which jurisdiction you have to file, because we have 4 offices: patent office Delhi, patent office Chennai, patent office Mumbai, patent office Kolkata. There are 4 offices, patent office in our country. These 4 offices, that country is divided in the 4 jurisdiction. The the north area covered by the Delhi office, the south area covered by the Chennai office, west area covered by the Mumbai office, and the east area covered by the Kolkata office. So person who is the inventor or who is the applicant reside in that particular jurisdiction has to file that application concerned office. For example, a person reside in the Uttar Pradesh, he has to file his application in Delhi office. A person who resides in the Gujarat, he has to file that his application patent office Mumbai. So that whole country is divided in the 4 jurisdiction, and an applicant has to file his application in concerned patent office. And the foreign applicant, the jurisdiction of foreign applicant decide based on the address of service of that applicant. So there are 2 modes of filing in the patent application in the office. First is physical filing, and second is the e-filing. We have the e-filing portal. You can file that application with the help of that e-filing portal, And the second one is the physical filing at patent office. That physical filing at patent office has several modes. For example, by post you can file your application, by register post, speed post with DD, physical filing at office counter. You can come to the office and directly physically file your application. Mode of fee payment at counter. You can file the fee of your application in mode of cash, demand draft or UPI. The second mode of filing is patent e-filing. With the help of e-filing portal, you can file your application in our office. This is the portal that comprises the e-filing is the link where you can go and you can file the your application. But for e-filing purpose, you have to the digital signature. Without digital signature, you cannot file your application through the e-filing portal. These are the filing procedure in our slides. You can go through these slides and get the idea of how you can file the your application through the filing portal. Now we move to the concept of what is what are the documents required to do to file an application, patent application. So first you have to has a covering letter. Covering letter regarding what is the annexure of that covering letter. And first the requirement of the document is Form 1. Form 1 is the document which is present in our website and in our portal. You can download that Form 1 and you can fill the details like name of the applicant, name of the inventor, and there are some certificates. You have to fill that form and you have to file that Form 1. Form 1 is the compulsory form which has to file during the application. Information regarding foreign filing, Form 3. Form 3 should be submitted in the compulsory document which is to be submitted at the time of filing. This form is related to the information. You have to produce the information whether you have made any foreign filing, that regarding the present application you have filed any your application in any other country or not. If you filed the your invention in any other countries like US, IPR, any other country, you have to mention that country name and the application number in that form. If you haven't filed that any foreign application, you have to mention that you haven't filed. You have to file proof of right. Proof of right is the right, that assignment which is given to the inventor to the applicant. If inventor and applicant are different, because sometimes applicant may be some institute like universities or some company. So that invention is done by any inventor, like for a faculty make an invention or some students make an invention. But if a filing done by an university or any industry, then the right from the inventor is given to that particular assignee. So that proof of right need to be submitted at the time of filing of invention if it is applicable. Prescribed fee need to be submitted, which is clearly present in our website. And that patent specification, that is Form 2. That is the main part of your invention, where you have to disclose your invention. That provisional specification or CS. It may be you can file either a provisional specification or if you have the your invention final stage, you can file directly the complete specification in Form 2. And that Form 5 need to be submitted, abstract and drawings and power of authority. If you are filing your application with the help of any agent, there are some certain agent assigned by our government, and with the help of a patent agent examination, some INPA number is given to that agent. So you can, if you facing some problem during the filing, you can file your application with the help of agent. Then you have to give the authority to particular agent that he can file on behalf of you. This is the fee schedule for the filing. For individual purpose, the filing fees is 1,600. Natural person. For company, it is 8,000. Recently, we that draft proposal is under process, and the educational institute is going to come under the natural person, and the filing fees drastically decreased by 1/4 for that educational institutes. This is the proposed amendment to the our act, and which is going to finalize. These are under draft version. So right now that educational institute has the 8,000 filing fees, but in future it may be possible that its filing fees decrease to the 1,600. There are some type of application. Ordinary application, that is covered under the section 9 and 10. Majorly the natural person or any person related to the industry or any Indian applicant files the ordinary application. Application may be with the provisional or CS. That ordinary application means that application is directly filed in the Indian Patent Office. Nowhere it is not claimed any priority from any other country. So second is convention application, and third is PCT national phase application. These two, convention application and PCT national phase application, is based on the treaties signed by our government. Convention application is the application in which a person is already filed his application in any convention country. Convention country is there is some Paris Convention treaties happened in past, and in that Paris Convention treaty, they certain group of countries decided that we are make a consortium. Any applicant which is filing his application in any of that member country can file his application to another country within 12 months and take the priority from the date of filing of first filing. So that convention application, the applicant has a 12-month window. He can file his application in any other country which is member of that convention, that Paris Convention treaty. That PCT national phase application is covered by the Rule 20, and this application is filed under the TRIPS agreement signed under the WTO, and the member countries of WTO and TRIPS agreements signee can applicant from that country can file that PCT application. And fifth type of application is divisional application, which is covered under Section 16, and patent of addition. What is the divisional application? Once an applicant has filed that application, and after filing he come to know that this application has more than one invention, so he can divide his application into the more than one part and file a separate divisional application for the parent application. And patent of addition, once the patent, once ordinary application, any application is filed and given a patent, but now the inventor has the idea, he can modify his invention, and he can add some part of his invention with the help of patent of addition, which is covered under Section 54. So I told about what is the document required at the time of filing of your invention. So once you file your invention, it cannot be directly given the patent. You have to file a request for examination. That is filed in the form of Form 80. That is known as RQ. You have to file request for examination to examine your application And once the examination is went through, you have if the application comply all the requirements of the Act, you have given the patent. So if you haven't filed any request, then there is no examination happen and no patent has been given. So that RQ need to be filed, and it may be filed within 48 months from that priority date. You can file at the time of filing of your application and or within 48 months from that your priority date, any time, but not after that 48 months. This is the simple steps for filing to a grant of patent. Once you file your application in our office, then after that 18 months that your application is published. That publication is published. After that, any person can make a position that he is the true and first inventor. Make a opposition. Then after the RQ, the examination process is begin. Once you file the RQ request for examination, that examination process begin. And after the examination, once the all objection is completed and complied within 6 months, the disposal, grant or rejection of the application happen. And if the application is granted, the LP is issued, and if it is refused, then these are the internal examination process of your application. That is fee structure for startup. That filing fee, e-filing fee is 1,600, fiscal filing 1,750. So if you are filing your application through the e-filing portal, the 10% given to that e-filing portal. If you filing fiscal filing, you have to give 10% extra fees. And now the government of India provided a new facility because many persons don't have much money to hire a patent agent, and many startups don't have money don't have idea to how to file his patent application. So government of India published a list of facilitators. A facilitator is registered patent attorney, and startup entity can choose the facilitator from the list provided on IPO website, our website. The facilitator can be chosen based upon the location and field of expertise. If the invention related to computer science, facilitator may be selected from that field. So on the basis of expertise and location, you can select your facilitator. So facilitator provides several services, including pre-application legal advice, preparation of draft for application, files the application on behalf of a startup entity, files reply to first objection report, and attends any hearing till the final disposal of patent application on behalf of the applicant. The fees for services are paid to the facilitator by patent office. Startup need not to be given the fee, any fee to that particular facilitator. So how to protect IPR? Set a goal, dream, imagine, write it down, and experiment, develop, modify, and construct your invention. And don't disclose your invention to anyone. It's a secret. And before filing your invention, you don't disclose your invention to anyone. Common mistakes generally done by the inventors. Many inventors publish their invention before filing patent application, because sometimes many students, many inventors publish their journal into the different journal, IEEE publication, and many journals they can publish their invention. So without filing your application, patent application, you should not disclose your invention to anyone. You should not publish your paper or any other thing into any journal. First file your application, and then after that you can you can publish your idea or anything, because first you have to get that priority date. Once you get the priority date, you can move to the you can make your invention public. use of invention in public or commercial use of invention in public, or even in a secrecy prior to filing patent application. You cannot use of your invention in public or secretly before filing your patent application. Wait until the invention is fully developed for commercial working before applying for a patent. Don't wait. Once you have an idea, just file your invention, because if you are waiting for your invention fully developed or for commercial use, it may be delayed and someone else get the priority date of your invention, because everyone is thinking and there is some race of time of race. So once you have idea, you have to file your application as soon as possible, because you have 12 months to file your complete application. You can complete your invention within 12 months and you can file that CS. And last common mistake that you not disclosing the invention sufficiently in the application. Many times I have seen encountered many of applications which are genuine invention, but in his specification he hasn't disclosed your invention completely. He just claiming that he in the form of result that he had produced a machine for this, but how this machine is working, how that efficiency of improve, the complete functioning and structural or functional feature of invention is not disclosed in the invention. So without the disclosure of that invention, the patent cannot be given, because patent is working on the concept of quid pro quo. Once you disclose your invention completely, the patent is given to you, because after that you have given the 20 years of exclusive right. After the 20 years completed, this idea, this invention is open to the public, and any person that can use, by reading of your specification, he can use that invention in his field. So you have given the 20 years, and after that 20 years, it is open to the public and used by any person in the art. So that your description may be sufficiently disclosed, so that the person is not make the invention enable. So you have to disclose your invention sufficiently. Thank you. That's all from my side. If you have any question, you can ask me.
Any questions from participants?
I think, sir, we will take up the questions at the end.
Okay.
As usually we are taking up.
Okay,
questions are posted in chat, so we'll take up. And
Okay,
sir,
no problem. You can carry on.
Okay. Thank you, Sunil sir. Thank you, Mr. Shukla, for an excellent informative session. We will surely follow up your valuable suggestions to strengthen our IPR cell at IMS Ghaziabad University Courses campus. Now, I would like to request my co-host, Dr. Anvesha Handra, to introduce our next guest speaker, Professor Sunil Kumar Sharma, School of IT, IMS Ghaziabad University Courses campus. Yes, ma'am.
Thank you so much, Professor Rakesh Roshan, sir. So a very good afternoon to all my dignitaries, fellow colleagues, and all the participants. Professor Sunil Kumar Sharma ji has more than 23 years of teaching, research, and industrial experiences. Professor Sharma has started his career as a programmer at Jayo Motors Limited. He has authored a book on computer graphics with Pearson Education publication. He has presented various research papers and national as well as the international seminars, and also attended various workshops. He has been the visiting faculty with various organizations like CCS University Meerut, College of Business and Studies Delhi University, MDU Rohtak, and many more. Professor Sharma has received the Teaching Improvement Award for giving highest average marks in university at ABES Ghaziabad. Professor Sharma has worked with various organizations like IGNOU and Krishnamurti Foundation, Varanasi, as a lecturer in computer application. Professor Sharma has also worked as an associate professor and associate head with ABES Engineering College for more than 5 years. He also worked with Accurate Group of Institutions as associate professor and head CSE department. Now, I would like to request our valuable guest speaker, Professor Sunil Kumar Sharma ji, to take this FDP to the next level. Over to you, sir.
Thank you, Dr. Misha. Thanks a lot for a nice introduction. First of all, I would like to express my gratitude to our director, Dr. Ajay Kumar ji, and the chairperson of the BCA program, Dr. Gagan Varshney ji, for giving me this opportunity to speak on role and importance of licensing in technology transfer. So basically, we have to understand, let me relate with this, the talk given by Vishal Shukla ji. Once we have got patent, definitely that concept, that process, that device is having some commercial value. So one has to identify that what is the scope or utility of that patent which can gain something commercially. Then definitely the technology need to be transferred either to some organization manufacturing that device or to some other research lab which can utilize that technology, which can utilize that process, that concept, whatever is being invented by you for further invention. So the overall objective of this whole process can be understood by TRL diagrams. Basically, we'll be discussing in my next slide. So the first thing which we have to understand that what is the technology transfer basically. So see, whatever the idea you have, whatever the process you have invented, whatever the patent you have got, you have well-defined, drafted that. So definitely that is need to be converted into the commercial value, so which you have identified. The major role play in this whole scenario is that normally educationists or the research laboratories, the people involved in that research, could not identify the commercial value of their product or the process. So for that, what is the idea? How they can come to know that how much they should negotiate with any organization or with any other research lab for their product, for their process, for their invention. They can pitch that idea after getting the patent to the different investors of that domain. They can assess their product, their process in the market, in open market. They can frame that. They need to give presentations to the similar people working in that domain so that they can understand the interest of the people or the valuation of their product or their invention can be genuinely identified. So next slide, please. So different things which we have to, host, please come to the next slide. Different points we have to understand properly. First of all, we have to understand what is the technology transfer. So technology transfer is basically the movement of the data, designs, inventions, materials, software, technical knowledge, or trade secrets from one organization to another or from one purpose to another. Purpose itself is included. Say, for example, you are doing that invention you have done for some different purpose, and it can have some utilities in other system, in other process. So you are giving one purpose to another purpose. You are giving to some another organization for either it can be a vertical diversion of your patent, of your research, or it can be a horizontal diversion of their patent. So that can be identified. And the person who has invented with his team, with the help of engineers, with the help of marketing people, with the help of legal persons, he can value that process. How much this has the value in the system. Next slide, sir, please. Once you identify the next slide, host, please. Once you identify, you have to understand in the whole process of commercialization, where is your research is actually lying. If you'll see, there are 9 total levels, TRL, technology readiness level, 1 to 9. Technology readiness level 1 to 3 are basically a part of the research labs or the university research. You have identified the research, you have completed the research, that is on the paper. You have tested in your systems, conceptualize that. Now, TRL number 4 and 5 is basically testing your concepts in the laboratory environment, and TRL 5 testing your concepts or the process or a model in the real environment. Once you test that in the real environment, you have to make the prototype with the help of some small scale industries or some other organizations which are working in the similar field. You have to share with that, and you have to share a memorandum with them that what will be the ratio of the profit which will be earning after converting into the real product. So this is the phase which we are actually capturing, TRL number 5 and 6. Transferring your idea, transferring your patent into a commercial product. So next slide, sir, please. So now we have to understand what are the different activities involved in technology transfer. What are the things involved? A long list of activities involved depending upon the technology, depending upon the product. Some of them can be followed, some of them can be left. Like securing patent and intellectual property rights. This is the first activity. If you not have secured your patent, you have not registered it in an IPR, then definitely if you expose it to the public, somebody else will utilize it. And then you won't be able to get the benefits. You have hard worked for 2-3 years. You made some process, you made some product, and you discuss with your competitors or with your friends, and that friend which you feel is good enough, rather than helping you, he has himself taken the patent, IP on that. So first of all, you must secure your patent by getting an IP. Second is assessing the commercial potential of innovation and inventions. What is the commercial potential it has? Definitely it has some value, then only you have taken the patent. You have filed an application, you have got the patent registered. So you need to identify the commercial valuation of that. Next, marketing technologies to potential licenses and partners. How you are going to approach the market? What will be the reach of this product? What will be the utility of this process? So how far you can utilize, either you can utilize in a village, or you can utilize this product at the national level. You can utilize this product at the international framework in different geographical conditions. It can be utilized. Then accordingly, you have to select a joint venture with the company to which you should license. Because you are licensee, you have to identify someone with whom you can get the maximum profit. There are different types of licensing. License is one of them. You see, different types of mechanisms, methods of doing the technology transfer. So number of methods are there. Like you people have heard the name of franchisee. Say NIIT technology franchising. Franchising is one of the method of sharing. Okay, so there are different types of methods we will study, and we will come to know that which one is the beneficial depending upon the process or the product which we have designed. Which method I should choose, that I have to select one. The next is joining up the research with commercialization principles and strategies, assisting with startup creation and development, securing funding for research and startup, negotiating license agreements and partnerships. This is what I am emphasizing most. Most of us are weak in this part. We are not able to negotiate the actual value of that. So we should identify the actual value. See, once your product is being actually in the real environment phase, it is tested, millions of the copies of that product will be manufactured. Now you can compute what is the manufacturing cost in bulk will occur, and if it is sold at a higher price, what is the percentage of appreciation on that? Definitely you should ask before giving your product or license to someone else that either in the course of production, for every item to be produced, some percentage, some royalty sort of issues should be asked, or you should not give the exclusive license to anyone of your product. If you are giving exclusive license to any company, any organization, you are losing everything. You are not having any rights later on. The company will earn everything with that. And you will be just getting only one-time payment. So the best way is to assess that what is the future scope of your product. Once you are able to identify the future value of your product being designed, definitely you will be able to earn throughout your life. Even your next generations will earn out of it. So I'll prefer that if such a product is having a value, the exclusive rights should not be, licenses should not be given to any firm. You should have non-exclusive so that you can give rights to another firms in the later stage and you can earn more money. Because that is why you have done that research. That is why you have done that. You have designed that innovation. And this one next is creating a business plan, building innovation ecosystem and structure to support and promote innovation and economic development. And the last is encouraging innovation and engaging in entrepreneurship to bring a commercial product to the market. That is the overall theme. The idea of the whole process of getting this FDP is to understand that how can I make my product commercializable? How can I earn money from out of it? That is the whole process. Next slide, sir, please. Host, please run the next slide. Now, what are the phases in the technology transfer? Usually we divide this technology transfer aspects into the 3 phases. These 3 phases basically are preparation, installation, and utilization. This is the broad classification of technology transfer. In turn, these 3 phases are actually converted into 6 steps of technology transfer. The first one is invention disclosure. To whom it is to be disclosed? It is to be disclosed to the patent office in writing. That's what Mr. Shukla was explaining you. Before you actually get the product converted, you have 12 months window. So write down, draft your concepts on paper properly. Submit this draft to the patent office. Partial submission. Okay, within 12 months, we'll convert this concept into the product. So invention disclosure should be given in advance to the patent office so that at the later stage, nobody else should claim that they have already designed this concept, they have already designed the product, and they should have the right on this. So revenue generation will go to them. Second is evaluation of that. Evaluate your product, evaluate your market reach, utility of that in the market. See, the more the horizon of your product is, more the value of that. For each item, say suppose you are designing a different type of mask. You can find out easily what is the utility of the mask in today's environment. Everybody is using. So if your mask is having some unique feature, which can be used as a USP, which others are not having, so it is having an edge over the others. So immediately convert this idea into the paper, and file into the patent office. And then design the product with the help of some, either you have to design it yourself or you have to take the help of some research lab. That's what I'm saying, that transferring, you have to, because convert it into a product. As a researcher, you are not having that laboratory to convert your product into the actual form. You can design a prototype, you can simulate it at the last. But at the end, you have to join the hands with some small scale industry or startup. The best idea is, rather than going to the larger organizations at the initial level, have a joint venture with some small scale industries. If your product is of that utility, if your research is having a further research aspect to be utilized in another research areas, then join with some research laboratory. Send your proposal to some research laboratory, but before that, definitely it must be communicated to the patent office. Then patent application, the third is assessment and marketing of your product, then patent licensing. Patent licensing, to whom you are going to license, you have to identify that, and then commercialization of that. So these are some of the things which one has to go through, and in this way, definitely you are going to have the maximum benefit of your research work. Next slide, sir, please. Host, please, next slide. Now, what is the importance of technology transfer? Whatever I have explained till now, out of this, you must have understood that whatever the product importance is, definitely more the value of the product, commercial value of the product you have, more the important is the transfer of that technology. It should not be transferred to anyone. It's not be given to any small organizations or the organization which is not having the specialization into that area. So the organization which is having the specialization in that area, you can transfer that. You can have a joint venture with them. The best idea is to have a joint venture, 50-50, 60-40. Some sort of negotiation should be there, because I have worked out on this part. So I should have more revenue share rather than you should have the revenue share. Or what you can do is you can have a license with them. Okay, you will have the funds. So whatever the investment will be there in your ratio, I am having the technology. I'll design some machine, or you can tie up with them some company which can provide you the machine to manufacture that. And over that manufacturing, whatever the manufacturing process will go on, for each manufacturing year, you can give some royalty to that company because you are utilizing their resources. Technology is yours, mindset is yours, conversion model is yours, and for manufacturing you have taken up, you have set an agreement with some other company which will provide that machine to you to convert this into a commercial product. So more the number of machines you will get free of cost, because you will be giving some royalty for the utility of that machine. So that way you will be having always control on your research. So rather than giving complete control to somebody else, and then just you feel someday that this company, I have given this idea, I have designed, I have converted this product into the real form, and they are now earning the money in crores. That's the thought the people have at the later stage. So next slide, sir, please. Host, please run the next slide. Now, what are the objectives of technology transfer? That's what my emphasis is. You should have a formal or informal cooperation between the laboratories and public and private sectors. The purpose of the transfer is to strengthen the economy by accelerating the application of the laboratory technology and resources to private and public needs and opportunities. Definitely, you are fulfilling the public needs, but along with that fulfillment of the public needs, definitely you are generating revenue. So in totality, there will be a boost to the economy. There will be a boost to the general public, either health or the service will improve. Some sort of improvement you have given to the society. So that way you will be always appreciated, and for that appreciation you will be getting a continuous revenue model. So that identification of the revenue model, you are a researcher, you may not be a business analyst, you may not be in that marketing analyst for that. So you can have association with the people for that domain. That is the best idea. Identify the experts of each domain and then take the help and then convert your idea into the product, real product, and then commercialize it with the help of some machines from an organization, rather than giving your technology to that company. That's what my advocacy for this part is. Next slide, sir, please. Now, licensing in technology transfer. We would have learned driving license, different sort of licenses. What we are getting with those licenses? We are getting an approval. We are getting an authority. See, once we have got the driving license, it means we have got an authority that, okay, we know the driving and we use that driving license. We pay some money for that, giving that driving license. They test our ability to drive and authorize that ability and issue a driving license. Similarly, you are giving an authority to somebody else, to some organization, that, okay, you can use this product, you can copy it in multiple copies, you can create multiple copies. Okay, you can have some knowledge I'm giving you, how to convert it, how to use it in further research. So this is the licensing. This is an agreement involving the transfer of rights from one party, which is the licensor, to the other party, licensee. These rights commonly control the use, like for copying, manufacture, sales, etc. of the IPR, patent or copyright material or confidential or the know-how process. So your process is being actually shared. So this is an agreement for sharing. So what type of agreement you have to sign? That need to be identified. Next slide, sir, please. Host, please, next slide. Now, different methods of technology transfer. We have to understand each method with the advantages associated with that method. Like licensing is one of them, which we are commonly familiar. But you will understand at the later stage, this method of licensing is the most dangerous one. And normally researchers prefer to do that. You are basically giving your whole thing, whatever you have developed, to some another organization that, okay, now onwards, you can create multiple copies of this product. You do manufacturing because you have the resources. I am a poor person and you earn money and give me some small part of it and I'm happy. So people normally do that. But there are better options. Your ability to negotiate with the people, your ability to have a team of members rather than standing alone, you should make a team of members. Okay. So another is support contract. Rather than giving a license, you have taken a support contract. You have signed a contract. Okay. Now we two together, I'll be sharing the concepts, and we two together will develop this and marketize it and commercialize it, sell this product. So support contract is being signed. Company is not interested normally in signing a support contract because you any day you can deny, okay, my contract is over, you are not meeting my terms and conditions. So I have not given you exclusive contract. So I need to hire now another contractor who will say, deploy more money and we'll work together. So this is having the risk with that. Next one is joint ventures. The big organizations, if the scope of your product is at the larger scale, then best is have joint venture with the company. And then once you have the joint venture, you may start giving franchises of your product. So franchising is a good model. In this model, you also earn money and you give some royalty to the company, which is giving you all sort of facilities in franchising. Their model you'll be using, their logo, their trademarks, everything, their marketing strategy. They will be giving you training and all. So franchising is a good option. But franchising is normally, if you as a researcher is not having all such resources, you are not having a well-established company, then nobody is going to take up your franchising. Franchisee people will try to have with the brand name associated with them. So you should have a joint venture in your domain, which is for that, whatever the domain or periphery of that product is, that which is having a value in the market. Yes, the name is there, that is famous for that. Have a joint venture with that and then start giving franchising of the product. So you will earn multiple ways. Next is the type of turnkey agreement. Equipment acquisitions. Equipment acquisition is a simple one, but it's not normally patented. You take up somebody has invented some equipment and you have signed an equipment acquisition, and now that equipment is being sold in the market with the trademark of that company. They are putting their logo on that. So because they have the market reach, they have the distribution system, so they have acquired your equipment and then they are selling it and giving you royalty sort of thing. So acquisition. This may include non-patented devices also. Management contract you can sign with some company. Okay, now we'll be having a management contract, that how we'll be going. Foreign company acquisitions. Bigger companies prefer to have the company acquisition of startups under this category. You have started some startup with the help of some small scale industry. Once it grows and they perceive that this has a value or turnover in the near future to be doubled or triple or 10 times, some foreign company will put a higher value, whatever you are having the current valuation, more than that, 30% higher, 40% higher. Acquisition of different, like Flipkart. People are having Indian, Bansals were having this company. So acquisition was there. So foreign company acquisitions, normally a larger group of companies which have the very high stake worth, they acquire the smaller companies, startups. Once the startup is having a value, say valuation of $10 million, somebody will purchase it to $100 million. You'll feel going to 10 million to 100 million will take me 5 years. So better to give this company and I will start some another one with the help of that, because I have the brain, I have the quality. So I'll start some another venture, and later on, some people are doing this. People from IITs, they have the startup, they do run that with the profit, have this acquisition to this level to 10 million, 20 million, 30 million, and 10 times somebody will purchase them because they perceive the valuation into that growth of that. So direct foreign investments, you can ask if your company is having that market reach, you're registered in stock market, then you can ask for direct foreign investment. Otherwise, FDI is not possible. Buyback contract is a better idea. In buyback contract, what exactly buyback contract is? See, you have designed some product, actually tested in the real world, and then you need some machines to manufacture that. So you have the contract with the company which is giving you machines, and your product they will purchase because they have the market reach, but they will purchase at the lower rate. So that way. Another is original equipment manufacturer, OEM. This is used in computer science product, hardware products a lot of OEM. What this OEM is basically, you have in your country, suppose you have very cheap manpower. Okay, so the company will invest, they will give you the plant. Okay, and now you will start manufacturing, and that manufactured product will be taken up by them with their logo, with their you are just a manufacturer. So this is OEM. Under OEM, you have to sell that product. The raw material cost you have to bear, everything you have to bear. Okay, the manpower is your, management is your, but you need not to worry to whom I have to give this product after manufacturing. That company will take up your product, but that will be taken at a very less cost. Say that product is having in the market normally 100 rupees, but you are giving it to 50 rupees. Reason because that company is having a larger market reach and your total production is being taken up by them. They have given you technology, they have given you all the infrastructure, they have invested the money. That is why you are just like a manufacturer for them, and they are actually getting the whole products and earning money out of that. So you are also earning some share of money, good share of revenue, but they are also the major share of revenue. Next slide, sir, please. Now, how technology transfer is adapted by SMEs? That's the whole point. Till now, we have been discussing that some idea, some product we have designed, we have to associate with some SMEs, small, medium-sized enterprises, and convert this product into a marketable product and identify the revenue, how much it can have, the reach. This product will be actually successful in the real market or not. Once the product is successful in the real market, I can ask for more revenue from the competitors. So technology transfer is important for small and medium-sized enterprises who are able to utilize the process to help them compete with larger competitors rather than having to pay for internal research and development. SMEs are able to form alliances with the fellow companies and research institutes to produce innovations, reduce financial risk, and share the technologies. That is the whole theme. We are reducing the risk, we are sharing the technology, we are reducing the financial burden, and we are getting return out of it. Because small scale industries are not having that much expectations. They are working with a small budget. So you can test for your product for 1 year or 2 years, and then you can have larger market reach. So next slide, sir, please. Now the conclusion of this whole discussion. The technology transfer serves to join research with real world products that can provide benefits for society, solutions to problems, and at the same time, generating profit that can be used to fund further research and development. Technology transfer is particularly important to SMEs who are able to leverage outside enterprise and research to develop and create new innovations that are ready for the marketplace. They have that have the utility in the society at a larger scale, the more the revenue you'll be getting. So that's my side. Thank you very much, all of you. Hope you must be having a good time, enjoyed this session. Now you can ask the questions. Session is open for question answer session. Professor Rakesh, somebody is having some questions in the chat box. I could not see any questions asked. Over Over to you, ma'am. Dr. Anvesha. Rakesh sir, are you here?
रक्षा से बात हो रही है। रक्षा बेटा बार-बार रजिस्टर कर रही हो और जगह कॉलेज देखो तो कॉलेज दुनिया पे आए तो गाजियाबाद किसी के लिए क्यों कर रहे हो? जब
हेलो,
बात हो चुकी है,
आवाज आ रही सर?
क्या हुआ इस बार?
आपकी आवाज नहीं आ रही सुनील सर?
सर मुझे आवाज आ रही है। होस्ट को बोलिए म्यूट कर दे पार्टिसिपेंट्स को। somebody has on this mic.
ओके ओके
आपने यहाँ पे कॉल किया था, आपकी डायरेक्टली ज्योति मैम से बात हुई थी?
ओके
तो फिर आप
thanks to Vishal Shukla ji for your valuable information, and it definitely strengthen our knowledge related to patents and whatever you explain the process, बिल्कुल step by step process जिस तरह से आपने बताया, it was very nice session. And again thanks to our colleague Professor Sunil Sharma also for the nice presentation and nice explanation of all the things very clearly, and very it was really very knowledgeable. I really enjoyed a lot your session. Okay,
Yes,
along with the session of Vishal Shukla. And also at last I want to thanks to our director sir for giving the opportunity for this FDP, and thanks to our chairperson BCA sir, and finally thanks to our IT support, and at last I also thanks to participants, because without participant no anything will be possible. Okay, thank you so much for joining the FDP. Okay,
thank you, sir.
Welcome, Rakesh.
Thank you, sir.
yes ma'am.